Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Well, I once had the late, great Adrian Sterling as a copyright professor at my LLM at Queen Mary University in London, and I loved the subject and the manner in which different cultures looked at creative works and innovation. But that was 20 years ago, and copyright is now back on the table of DPOs, CPOs, and even marketing technology people who started dealing with privacy work and now have been charged with AI governance. So, of course, AI governance may seem like a natural fit for privacy experts, to the point that data protection authorities are also starting to double down as AI supervisory authorities, and well known professional associations are adding AI related topics to their conferences and training courses. But as you all know, by simply looking at the proposed EU AI Act or other frameworks, or by reading the news, AI governance is also overlapping with copyright law in a big way. And once stepping into this minefield, many of you may feel completely out of your element. So, as much as we may love the novelty, you may not have looked at copyright law since law school, if at all. So, we need less speculation and more real experts, and we have found a top one for the matter at hand. Jakob Plesner Mathiasen is an attorney with a focus on intellectual property and emerging technologies. He serves as the secretary for the Danish Society for Copyright Law and is the mind behind the Danish Entertainment Law podcast. He also teaches entertainment law at the University of Copenhagen. With Jakob, we'll try to better understand the copyright implications of generative AI now that fair use or fair dealing, depending on your jurisdiction, don't seem to be the silver bullet that many hoped. When it comes to training foundation models or the many AI tools now exploding all over the place on top of such models. So, a few questions that we need to look at. Can the exemptions that we already have, so written in the law, be understood to include text mining or data mining for machine learning purposes? Is the output of a simple prompt on Midjourney or DALL-E copyright protectable? What do we do if Japan, the EU, the US, China go in very different directions in their answers to these questions? As a note, I will add that whenever we mention the DSM, we refer to the 2019 EU Directive on Copyright in the Digital Single Market. There's a link to it. And that when Jakob talks about the InfoSoc Directive, he refers to the prior 2001 directive dealing with the initial copyright challenges presented by the internet back then. Let's go for it. Jakob, thanks for coming.
Thanks for having me. It's a pleasure to be on your podcast.
It's so good to have someone from the copyright angle. We have a lot of people talking about AI, and these days it seems like everybody who is doing privacy now is an AI expert.
I think the same goes with copyright. I've seen a lot of AI experts within the copyright world. But I think the fast development has taken caught everybody with surprise since the launch of OpenAI's ChatGPT in November.
People are excited, and that's always good. And this burning question, and I'll start with that. So starting with the end, in a way, which is copyright exceptions, because everybody has heard that ChatGPT and other sort of foundation models have been trained on works which were originally protected. And we know about the Getty Images lawsuit, and we just heard, or maybe a few weeks ago, about another lawsuit which I think came from the creator of Game of Thrones.
Yeah, I think it's George Martin.
Okay, thank you, George Martin. So, assuming that it's happened and that we have been training all of these algorithms on works that were publicly available but protected, are there any exceptions?
Well, if we look at the European situation first, because we need to acknowledge that there probably will be a difference between different jurisdictions, the US, Japan, Europe, and the like. In Europe, we have exemptions that might be relevant for training of AI. The problem with these exceptions, though, is that when they were made in the InfoSoc directive and in the DSM directive, the latest, no one could foresee the generative AI engines that we have today. So we have in Europe two main exemptions. You have one for actually machine learning, temporary copies in the InfoSoc directive, and you have one for text and data mining, which is something that AI does. It mines data and text and learns from it. The problem, however, I would say the million-dollar question is, does these exemptions also cover works generated by AI and the training? And I'm sad to say that it is probably not settled, at least it's not clear from the legislation. I think it is clear that they can train at least to some part the engines, but yeah, in Europe it is unclear whether the output from the engine is legal. And as you say, we have seen cases in the US, the latest with Grissom, and you mentioned two cases. There are plenty more, either going on or there will be. In the US, the law is of course different than the European, and yeah, you have to look at fair use, for example, but we have to settle it by courts. And one thing also worth mentioning, in the European legislation, you have the possibility to opt out and say to the AI engines that they're not allowed to train on your data. Again, this is a data podcast, so we can be a bit nerdy about it, but you both have to do that in a way that is legally solid, but also technical solid. So actually, it can be a bit difficult for a right holder to be aware that they have to opt out and also to do it in the right way. And when you then add that it's uncertain whether or not they are actually allowed to train your data, then I would say it's fair to say that the legal status in both Europe and the US is quite murky. And we need to have some court cases to settle the issue.
When you mentioned the opt out for
Yeah,
personal data, I think there's a funny overlap where someone may be both protecting their privacy and their work. You've got your memories, like your life memories, so you're writing about it. It's creative, it's a work of art. In a way, it's a work. But you're talking about yourself, so it involves your privacy and it involves your creation. So that's a place where you've got privacy and copyright. Does it ever come up, or is it a crazy
no,
thought?
it's not a crazy thought at all. And I think what has, in Europe, again, that's of course my home field, what has struck people by surprise in Europe is that if these exceptions with text and data mining in the DSM directive, if they are valid and can be used here, then you change the whole situation and the game as we know it. Because normally, when it comes to personal data, when it comes to copyright protection, as a right holder, as a person, there's a general, at least copyright, there is a general principle that you need to give permission. You need to opt in, as you, if you put that term, for someone to use your material. And right now, at least to some extent with text and data mining, people can take your content unless you opt out, and you opt out in the right way. And that frustrates many right holders because they fear that they now have to, and the same goes with personal data, I guess, that they have to be their own detective and look at all these AI engines and say, do you have my data? Have you trained on my data? And do you accept my opt out my own reservations? And that's something at least I know that many right holders fear. And again, it is not something that is has been cleared either by legislation or by the courts yet. So it's an interesting situation where I think everything is up in the air, which is, of course, demonstrated by the many lawsuits around the world.
Yeah. So what I'm thinking is that, in a way, this is not revolutionary in the sense, meaning the migration from an opt-in, where I need to ask you if I want to use your article for a derivative work. I need to ask you first, as it used to be the case. With the advent of YouTube and all of these platforms where you've got an automated system to scan through the music that you use as a background to then tell you whether it is protected or not, and then people sort of negotiating in bulk, right, those rights to sort of compensate by default, assuming that there is no way you're going to have a workflow in place for the prior approval. So if we already had a slow migration towards an opt out, simply because again everybody became an editor and a creator and and an author in a way and a publisher, it's only one step farther. Is that
You
right?
could say, I think that the analogy to the cases with the platforms that we know with user-generated content like YouTube is quite on the mark. You could say in the old Web 2 world with user-generated content prior to the DSM directive, these services were able to have user-generated content on their site without, at least to some extent, the permission from the right holders, unless they were in bad faith. And the right holders had to have these notice and takedown, which in the Digital Millennium Copyright Act in the US is the same or was the same in Europe with the E-Commerce Act. They had to every time go out and say whether the content had been used and whether it should be removed. I think you say, then the content were licensed. This training data could be licensed as well. We're seeing progress on that as well. And then, of course, that's a different ballgame. We got a new regulation in the DSM directive, Article 17, which changes the situation with user-generated content. But I see similarities between the user-generated world and the right holder's position, and then this training data world where we have this situation where it's blurred whether or not these AI engines are allowed to use data. But I hear from at least European politicians, especially the Danish, of course, my home country, that they are aware there was this uncertainty previously with user-generated content, and they want to avoid having the same situation with AI. So I think it will be cleared up right quite quickly. I think it was the president of the European Commission, Ursula von der Leyen, who also said that they were working on developing global standards quite urgently. So we need to have that fixed sooner than later.
Well, I read about Japan, where I believe their copyright act was amended in 2020, if I remember. And then it was so recent that they could already squeeze in an exception for, or an exemption for text mining.
Yes, I've heard about the Japanese approach. Of course, I'm not an expert in Japanese law, but um, it points in the same direction as some interprets the European legislation, that text and data mining is okay unless you have opt out. And again, and therefore it becomes a difficult subject and discussion. But there is a difference between text and data mining where you learn a system something. For example, I think that you can give it a vast amount of data, and then you can make it analyze if you give it traffic data about public transportation, it can then analyze a lot of data about where are the risks at, when is there a queue in the transportation system, when is there risk of accidents, etc., etc. And it needs, of course, to be trained on a lot of data to learn this. That was something basic that could be done with legislation when it was made. But then you have this completely different system, the generative AI, where it can also create products. So you could actually have a situation where we could say, okay, perhaps you could use these exceptions to train your systems. However, the products that come out of the systems need to be looked at separately. So you can actually make products out of the systems. You can only use them to obtain knowledge. That's also a theory that is spinning around currently. So you have different possibilities from it's legal to it's not legal, till this mixed situation.
Yeah, this idea that whatever you create, yes, you need permission to build a collage or to put together pieces from others, but then you have your own input into this thing, like so many artists. And that new work is protected. What you say now, if I understand well, is that we are going to introduce constraints to the level of protection that we grant whatever is produced through tools that have been trained on such non-consented works.
You might, it's up in the air at least that the output, even though you have an exemption for training the engine, that it might not cover the output. That's at least something which is has not been settled yet, and I'm just introducing it because it could be very black and white when you discuss this. Either it's legal or it's illegal with the training. But you could have this mixed situation. And of course, a mixed situation is not preferable because it's easier to say that, okay, it's either legal or it's illegal, and that also goes for the output. But keep in mind that no legislation, perhaps with the exception of the Japanese, was made when generative AI was really at the table. And I would say that's in my world when ChatGPT was launched in November last year. That's the date, the iPhone moment, as we call it. But there's another issue. I don't know if you want to discuss that. That's of course with the output,
Please.
whether or not that's copyright protectable, because if we look besides the machine learning, which is the hottest topic right now, which is the center of all the lawsuits, then we have a close runner-up, which is also the center of lawsuits and also a lot of applications to the US Copyright Office. And that's whether or not the output could be copyright protected. And also, I would say a follow-up question, whether the output could infringe other persons' copyright and who's responsible. There are a lot of lawsuits surrounding those issues. And that's, of course, because normally our classical view of the subject was, and that goes for all jurisdictions, if you need copyright protection, then you have to have human intervention. You have to have some creative choices. And, I've also been teaching at the university at Copenhagen. And normally we also said, and that therefore, and it was just a simple question, can animals have copyright protection? No. Is there any case law? Yes, we have a case law from the US where a monkey took a selfie, the famous monkey selfie, and therefore no copyright
Yeah,
protection. And
yeah.
can machines have copyright? No. So if you and a computer make a random image, it's not protected by copyright. And then generative AI entered, but then generative AI enters the stage, and suddenly you have a lot of problems because if you go into Midjourney or DALL-E and enter a very specific prompt, draw a picture of a cat surfing the waves outside of San Francisco. The sun is shining, use this camera and use this, and this. You have this picture. And is that copyright protected?
Yeah, is there a new bicycle for the mind, and therefore it's your mind and it was your prompt? And how easy do we need to make it, or how hard do we need to make it? We have been listening to people in the US saying that fair use would cover it so far, and that just in case it wasn't, the new opt-out proposed by OpenAI, which is that you simply add the GPT bot to your, robots.txt
Exactly.
file on your website, for example. It would just keep that user agent out of the scraping and scanning your content. But if it wasn't that clear, we wouldn't have had two things we've seen. Adobe has been training their own Firefly product on their own copyrighted, bank of images, and claiming that they would help people out if anybody who used Photoshop or any other products to produce new images with Firefly was ever sued by someone. That's how confident they said they were. Then Microsoft, as a a reply to that, a few weeks later said, "Look, we are using OpenAI, but if you are sued, we will protect you. We will go to court." And I never understood whether it was they really want to be the ones acting before the court to make sure that case law goes in their favor, or whether they want to simply take care of the fees, which doesn't sound so likely. But I don't know. So my only point is that fair use is therefore not so clearly established. So in that context, we have this scenario. Let me just give you an example. I think it was 20 years ago that we had Vanilla Ice writing that. So you
Yes,
remember
yes, yes.
Vanilla Ice with Ice Ice Baby? They were sued by Queen. Was it Queen or David Bowie? I think it was Queen.
Yeah, but I think he lost, and then he bought the composer's right to, as I recall it, he bought the right to the composition owned by David Bowie and Queen. So he actually lost, but then ended up by buying the composition. At least I have to check it, but that's how I recall it.
Or it's a happy ending then. But I was thinking, picture, Vanilla Ice today, right?
Yeah.
So Vanilla Ice goes and searches for a rhythm, for a beat that he likes, and he makes a tune out of that using, generative AI. And in the past, we had that scenario. He never asked for their permission. Today, there'll be billions or millions of vanilla ices out there producing, millions of ice babies. And we may end up in a scenario in which all of them are simply going to be going ahead, producing this content, bumping into each other when they reach Spotify, for example. And then if they are not finding an opt-out, hoping for protection for every single one of these works. Do you think the world can get to such wild scenario?
I think that a lot of these wild scenarios they will be avoided because I have a lot of trust in the copyright system, and so you need. I think some of these issues may be done a bit more complicated than they are. I think that I acknowledge that the training data is very difficult and murky, but you have some basic rules regarding copyright protection, as we spoke about. When is something protected, and when it comes to, if I understand your question correctly, if you can have a lot of uh, copies or sound-alikes or the like, then we actually have a quite strong protection for against sound-alikes. And I know that streaming platforms like Spotify, I think they will do a good job in cleaning out all the AI rubbish, because I think that the larger music labels that will tell them that they have to do so. And when I say AI rubbish, I think please don't misunderstand me, because AI can do a lot of good, but it's when someone deliberately tries to rip off someone's song and just make some easy bucks. And we're seeing a lot of that currently, and you can of course upload a lot of AI generated songs which are not actually songs but just rip-offs, and then earn a lot of clicks. But I think that's something that will be avoided. But we will have some interesting cases with both sound-alikes and copyright protection.
So, Jacob, last thought. Do you think this will end up in Geneva? Do we end up with some sort of agreement at the WIPO?
I think we will end up with some sort of harmonization. And I'm quite positive on that. And I'm actually also quite positive that it will go quite quickly. The EU, the US seem to be of the same quite committed to finding a solution. And so therefore, it's an interesting situation. It's unclear in almost all territories, a lot of these issues, but I think we'll have it harmonized, and also in perhaps quicker than people think right now.
Very good. Good for lawyers.
Yeah.
Thank you, Jacob. Thanks again.
Thanks so much for having me.
Okay, that's all for today. And you will find some episode notes and links to our social channels on mastersofprivacy.com. Thank you for listening.